community television network.
Good evening and welcome. On behalf of the University of Maine Law School, the University of Southern Maine, and the Greater Portland community, it is my very distinct pleasure to convene the fourth Frank M. Coffin Lecture on Law and Public Service. Could we possibly have a more pertinent topic than race and criminal justice to mark this evening's event? Could we possibly have a finer commentary on that subject and commenter than the Honorable Drew S. Days III, Solicitor General of the United States? For most of us in the legal profession, the opportunity to participate in a United States Supreme Court decision is the event of a lifetime. For Drew Days, it is Tuesday. Part of his life at the Solicitor General's office, and as one looks back over the distinguished list of former Solicitors General, General Days is in good company indeed. John W. Davis, Stanley Reed, Robert Jackson, Simon Soboloff, Archibald Cox, Thurgood Marshall, Erwin Griswold, Robert Bork, Wade McCree, Rex Lee, Charles Freed, Ken Starr, former Solicitors General, names well known to many, if not all of you. In just 4 years' time, the Coffin-Lecture has attained heavyweight status. Joe and Ole Rao, Justice William and Mary Brennan, Professor Arthur Schlesinger Jr., Judge Patricia Wald, Solicitor General Drew Days. And the topics: Supreme Court confirmations, multiculturalism and American law, the realities of public interest law and practice, selective prosecution in the federal criminal justice system. It is fitting at this event that we honor one of Maine's and the nation's finest, the Honorable Frank Coffin. It is worth pointing out that Judge Coffin does far more than simply lend his name to this series. He is an active, enthusiastic participant in all of the planning, and one of the great joys of this dean's job is the meetings of the Coffin-Lecture Committee. This was a happy year for Judge Coffin. He was recognized by the American Law Institute, itself the gathering of distinguished practitioners, judges, and academics, as a 25th year member, attaining life member status. And as is tradition in the organization, the 25-year members always select one of their own to be a speaker at the American Law Institute meeting last May in Chicago. No great secret, the speaker was Frank M. Coffin. And as I look down that list of distinguished lawyers, judges, academics in the 25th reunion class, I could not help but think many of them were saying, in any other year, I would have been up there as the speaker. But who could compete against Frank Coffin for an after-lunch speech? And just as we suspected, Judge Coffin's remarks were witty, wise, and we will see prescient, because he looked 20 or 25 years into the future, seeing what American law, the American judicial system, the American political process would be. Judge Coffin, may I ask you to introduce our distinguished guest tonight?
General Days, Dean Zillman, thank you for that introduction. I am indeed honored to have the privilege of doing this chore. I would preface this by remarking on my thought a few minutes ago how much people like Ralph Waldo Emerson and Charles Dickens missed on the lecture circuit. They would come to a hall like this and they would get up, face the podium and speak. But we had all the luxurious duct taping of the microphones, and this is progress, you know, that we... I pity those poor people who could just get up and speak without the intervention of fallible technology. Now, unlike those who have appeared in this lecture series in other years, our speaker tonight merits not only some defining comments about himself, but also about the position he occupies. For while we can assume that everyone knows what a lawyer does, like Joe Rao, what a Supreme Court justice does, like Justice Brennan, and that many, if not everyone, know what a chief judge of a federal court of appeals does, like Judge Wall last year, the office of Solicitor General of the United States is not generally on the tip of everyone's tongue. Let me begin by saying that it does not mean that he is the boss of everyone on the street who is soliciting in Mrs. Warren's profession. Second, the Latin word root, solicitari, doesn't quite grasp it either, because that means to agitate or disturb. And our speaker tonight spends most of his life not trying to disturb, but trying to create the conditions that will prevent disturbance and make agitation unnecessary. It is an English title, but even then it's inaccurate, because the English solicitor is not a member of the bar, a barrister, and he can argue only in the lower courts, while our Solicitor General is the mirror image and appears only in the highest court of the country. What it is, this job, as many of the nation's top advocates mentioned by Dean Zillman have testified, is the best legal job that the executive branch of our government offers. Created in 1870, the position clearly calls for a top political quote-unquote appointment, but uniquely it offers the occupant of that position a freedom to exercise his own independent professional judgment in most situations. Only rarely is the basic rule violated. When my law school dean, Erwin Griswold, first worked in the SG's office in 1929, he was one of only 5 assistants. It had this virtue of being small. It still has that virtue. When Dean Griswold became Solicitor General himself in 1967, there were 16 assistants, and even now, General Days tells me there are only 24. But the universe of responsibility is enormous. The office represents the United States before the Supreme Court in every case in which the U.S. is a party. And this means that last year, in 2/3 of the cases heard by the Supreme Court, the Solicitor General or an assistant had to brief or argue the cases before the court. He, moreover, in controlling that, he's sort of a gatekeeper, and he is, in a sense, custodian of the quality of government advocacy, often rewriting the briefs of agencies and departments. But perhaps the most onerous responsibility is deciding when the federal government should take an appeal from any adverse decision in any of the 13 circuit courts of appeal. This decision is not left to the nearly 100 U.S. attorneys, or else they'd appeal every adverse decision, and our court and the Supreme Court would be flooded with appeals. But this means, on the part of the SG, making over 1,000 decisions each year. I have two vignettes of this process, neither one of which can be called typical. The process being deciding what cases where the government has been licked in the lowest level they can appeal to our court or the Supreme Court. My first vignette involves Dean Griswold, my own dean, when as a raw youth, just out of law school, he served as an assistant to Charles Evan Hughes, then the Solicitor General, and of course later to become Chief Justice. Hughes would become so absorbed on working on the merits of a particular case, writing the brief, preparing the argument, that he would forget the gradually accumulating piles of briefs that were stacked up behind his chair. And young Griswold saw this with increasing consternation and realized that time was running out, there were deadlines, and if Hughes missed some deadlines and failed to appeal an important case, he could be severely criticized. So the young law graduate took it into his heart and courage to send telegrams to U.S. attorneys all over the country saying, please file a protective appeal. We could dismiss it later if it didn't prove meritorious. But in this way, he saved Hughes's skin. He felt it was brash, and of course, any of you who've seen the pictures of Charles Evans Hughes knows he was a very awesome personality. Griswold reports his reaction. He never thanked me, but he never criticized me either. Well, times have changed, and I know that cases pending decision are not stacked behind Drew Day's chair. Today, there is a very sophisticated and layered process of decision. But I've heard one story from a generally unreliable source that opens a little window on how some things are done. It seems that General Days was teaching a class at the University of Georgia. In the middle of the class, he was interrupted to take a call from the White House. A court of appeals had just ruled against the government. The president was to have a press conference in 10 minutes and would be asked if the government would appeal. He was told, "You have 5 minutes." Our Solicitor General paused, drew a deep breath, then with great deliberateness and aplomb announced, "In our considered opinion, we will authorize an appeal." Well, enough about the office. Now, perhaps too much. Now, something about the man you may not have known. Like Gilbert and Sullivan's modern Major General, this modern Solicitor General is a man of many parts. To the somber vestments of the office, he has added considerable panache in food, fashion, and song. As professor at Yale Law School, hosting students at his home, he would serve the humble fare of pizza. Since then, my unreliable informant reports, he has developed gourmet tastes and leads his assistant solicitors on forays to try out various bistros and their exotic specialties. These young assistants are no fools. They are keeping and saving their gustatory notes. So do not be surprised to read the bestseller list someday and find The Workaholic Gourmet or Gourmet Forays with General Days. As for fashion, he, together with the vice president, set off a minor trend when they both appeared on crutches with injured Achilles tendons. For a time, no one was anybody who could not produce an ailment traceable to characters in the Iliad. And finally, song. Whether or not the President expects talented guests to sing for their supper, it is again reported that on the occasion when the Yale Russian chorus appeared at the White House to honor Boris Yeltsin, our Solicitor General joined in with his mellifluous tenor. Truly a very modern Solicitor General. Though still a young man, our speaker is completing 3 decades of dedicated action, scholarship, and teaching in the very crucible of stress in modern law and society. As lawyer for the NAACP Legal Defense Fund, as Assistant Attorney General for Civil Rights, as law professor and director of the Shell Center for Human Rights, and now as Solicitor General. I had the privilege this morning of listening to General Days as he spoke in a crowded lecture hall at the law school. At the end, I could not imagine having a more inspiring law school experience than to listen to one of the nation's top legal officials who is at once a person of high competence, proven dedication, refreshing candor, and unblemished character. I present with pride Solicitor General Drew Days.
Thank you very much, Dean Zillman, and thank you, Judge, very much. Until you spoke, I thought that Director Free of the FBI was my friend, but your report suggests that I may have been misled. I was also struck by the extent to which your sense of humor and that of my older daughter seemed to coincide. When I was nominated to become Solicitor General, I went down to Washington alone. My family remained in Connecticut. And so when I returned, I expected that there would be a brass band or a red carpet at the airport to greet me. There was nothing of the sort. I looked around for any signal that someone was going to greet me and meet me at the airport. I finally saw a car that looked very much like our family car, but it had a red sign in the front passenger window. And I was sufficiently myopic to think that that was not our car. That's not normally the way we travel. But as I got closer and closer to the automobile, I realized it was our car. The sign in the window said, "No soliciting." That kind of put me in the right frame of mind for the rest of my tenure. Judge and Mrs. Coffin, Dean Zillman, members of the faculty, staff, and student body of the School of Law, other distinguished members of the Maine bench and bar, ladies and gentlemen, it's truly an honor to have been invited to give this year's Coffin-Lecture on Law and Public Service. I know that my former colleague at the NAACP Legal Defense Fund, Professor Melvin Czar, and my law school classmate, Professor Martin Rogoff, played a significant role in making this visit possible, and for that I'm profoundly grateful. As most of you are aware, Judge Coffin enjoys a distinction shared by very few other Americans, that of having served in all 3 branches of the federal government during his outstanding career. I know of only one other, Abner Mikva, who's the counsel to the president, who enjoys that distinction, although I assume that there are a few others. I cannot think of anyone who embodies more than he does the ideal of the dedicated, effective, and compassionate public servant. And I want to express to you, Judge Coffin, a more particularized thanks as one who has spent many years as an appellate advocate and who now devotes substantial time, as you indicated, as Solicitor General, to arguing cases before the Supreme Court or supervising a staff of talented lawyers who also appear before the court on a regular basis. I think that I'm in a good position to note Judge Coffin's active interest in the character and quality of oral argument in his thoughtful writings and lectures on appellate advocacy. His efforts in this regard, I can assure you, have had an important and lasting impact on the professional development of thousands of lawyers. I've selected as my topic for the this evening, Race and the Federal Criminal Justice System, a look at the issue of selective prosecution, because I wanted to explore with you one of the most difficult and troubling questions that an important group of public servants, federal prosecutors, face today in carrying out their responsibilities. My credentials are not those of a frontline courtroom prosecutor. Indeed, those familiar with my background as a civil rights lawyer at the NAACP Legal Defense Fund and as Assistant Attorney General for Civil Rights in the Carter administration may find it difficult to view me as a prosecutor at all. But the truth is that as head of the Civil Rights Division, I authorized and supervised hundreds of prosecutions involving credible charges of constitutional violations by law enforcement personnel and of private parties subjecting others to conditions of peonage or servitude. With a few exceptions, the division's prosecutorial authority comes from statutes passed just after the Civil War with the protection of newly freed slaves in mind. In my capacity as Solicitor General, as Judge Coffin noted, I am much more removed from the prosecutorial process at the trial level, but bear ultimate responsibility in the appellate courts for many prosecutorial decisions made at lower levels in the federal criminal enforcement process. I become involved at the Supreme Court stage in determining whether the United States will seek review of adverse lower court rulings, both criminal and civil, and what arguments the government will make in such cases in response to numerous filings in the Supreme Court made by those who have lost to the government below. The vast majority of such petitions are from convicted federal defendants. Members of my staff and I argue about 2/3 of the cases, and quite a few of those, usually 50%, involve criminal matters. In the Supreme Court's recently ended term, my office was involved in federal criminal cases presenting a range of issues from conspiracy, false statements, sentencing, obstruction of justice, and of Congress's power under the Commerce Clause to criminalize gun possession on school grounds. As we participated also in several non-government criminal cases, we had to address such questions as the constitutional status of knock and announce requirements and the applicability of the exclusionary rule to circumstances where the court, rather than police, erred in ways that resulted in arguably illegal arrests. During these years of service in the Justice Department, I've had an opportunity to work with hundreds of dedicated prosecutors, women and men of all races and creeds, in Maine justice and in the United States Attorney's offices around the country, who are committed to ensuring that all Americans are afforded the protection of the federal laws and Constitution, and that violators of those laws are subjected to even-handed justice in our courts. As a group, they have shown special concern for the degree to which drug trafficking and attendant violence in recent years have taken a disproportionate toll in African American and other minority communities across the country. I think they feel, as I do, that unless there is vigorous enforcement of the law, swift punishment for predatory criminals irrespective of race, and procedures for making restitution to victims of crime, it is difficult to imagine how African American communities, especially in our major urban centers, can serve as viable environments for the normal activities of life, such as education, employment, economic development, and entertainment. Consequently, any suggestion that the enormous power of the state in the form of the federal government is being used in a selective and discriminatory fashion to prosecute and punish blacks more often and more severely than whites on the basis of race places in doubt the validity of the entire enterprise. It is a charge that we are, in effect, part of the problem rather than part of the solution, that we are contributing not to the improvement of the quality of life in black communities, but rather to the destruction of those communities. Certainly, selective prosecution on the basis of race, color, and national origin have occurred in our history as a nation, and presumably will happen from time to time in the future, humans being what they are. One has only to recall the famous case of Yick Wo versus Hopkins in the 1880s, where the Supreme Court found that San Francisco authorities were selectively enforcing against resident Chinese, but almost never against whites, laws prohibiting the locating of hand laundries in wooden structures. There the court found that the law was being administered, and I quote, with an evil eye and an unequal hand. Yik Wo and other similar cases in the past have taught that to the extent such violations of constitutional rights are not dealt with promptly and firmly, undoubtedly all law enforcement suffers thereafter by having similar charges leveled at perfectly sound and legitimate prosecutions, and the overall credibility of the criminal justice system called into question. As has often been noted, the support of the citizens for our judicial system depends not only upon its being fair in fact, but that it appear to be fair as well. The department's publicly available principles of federal prosecution, promulgated originally in 1980 during the Carter administration, capture this point well, I think, in the following words. The availability of this statement of principles to federal law enforcement officials and to the public serves two important purposes: ensuring the fair and effective exercise of prosecutorial responsibility by attorneys for the government, and promoting confidence on the part of the public and individual defendants that important prosecutorial decisions will be made rationally and objectively on the merits of each case. That is why we in the Department of Justice are extremely concerned about charges of selective prosecution on the basis of race in the federal criminal justice system in three specific areas. One, the prosecution of crack offenders. Two, the imposition of significantly harsher penalties for crack as opposed to cocaine powder offenses. And third, decisions with respect to seeking the death penalty. In each of these areas, the Attorney General and other top Justice Department officials, including myself, have gone to great lengths to evaluate these claims and have found no basis for believing that they accurately describe the way in which federal prosecutorial decisions are made. Nevertheless, we also believe that federal prosecution practices should be the subject of ongoing research and review to ensure that they are consistent with constitutional norms and the policies of the Clinton administration. A recent decision by the United States Court of Appeals for the Ninth Circuit, which is a circuit that encompasses many of the western states, including California, in a case called United States versus Armstrong, has spawned a number of selective prosecution claims by African American defendants charged with crack cocaine offenses. Armstrong presents the question of what degree of evidence a defendant must adduce to justify an order requiring discovery from the government on a claim of selective prosecution. Discovery, for the non-lawyers in the audience, meaning that the government has to divulge to lawyers for the defendants information about the decision-making process that led up to the bringing of the indictment. In Armstrong, 5 black defendants indicted in the Central District of California, which includes Los Angeles County, on various crack charges, alleged that the U.S. Attorney's Office had determined to prosecute them because of their race. These prosecutions involved more than twice the quantity necessary to trigger 10-year mandatory sentences. There were multiple sales involving multiple defendants, at least this is what we allege, thereby indicating a substantial crack cocaine ring. There were multiple federal firearms violations intertwined with the narcotics trafficking. The overall evidence was extremely strong, including audio and videotapes of the defendants. Threats had been made to the arresting officers by one of the defendants, and several of the defendants had criminal histories, including narcotics and firearms violations. Nevertheless, in support of their motion for discovery, the defendants offered one item of evidentiary support, an affidavit from a paralegal employed by the federal public defender, stating that in 1991, all of the 24 defendants in crack cases closed by that office were black. The defendants asserted that this statistic alone lent support to their claim that blacks, but not whites, were being prosecuted federally rather than by the state to ensure that black defendants would be subject to the stiffer federal sentences if convicted. The district court was showing sufficient to justify discovery, a ruling that was upheld by the Ninth Circuit. In our view, the Ninth Circuit's ruling in Armstrong significantly relaxed the previously accepted standard in such cases, namely that of showing evidence of similarly situated non-minority defendants who were not prosecuted, that defendants had theretofore had to meet before they would be entitled to discovery on a selective prosecution claim. Because discovery on these issues is extremely burdensome and time-consuming and may require the government to disclose internal information typically thought to fall within the wide discretionary berth afforded to prosecutors, Armstrong raised an issue of substantial importance to federal law enforcement. As a consequence, I recently authorized a government petition to the Supreme Court to accept the Armstrong case for review in hopes of obtaining a reversal of the Ninth Circuit's decision. That petition is pending. In another recent case from the Central District of California, two defendants charged with crack cocaine trafficking offenses sought an order compelling discovery in connection with their claim that the government had chosen to prosecute them because they were black and Hispanic. The defendants relied primarily on a study purporting to show a statistically significant disparity between the number of whites prosecuted for cocaine-based offenses in state as opposed to federal court for the years 1989 to 1991. They also relied upon the same affidavit that was important in the Armstrong case. We filed an extensive response to the motion, including numerous affidavits and supporting documentation explaining specifically the basis for which these particular defendants were targeted for prosecution and, more generally, the race-neutral criteria used to determine what offenders will be federally prosecuted. In this case, unlike in Armstrong, the district court denied the defendant's motion. This latter case, however, is an example of the enormous investment of resources required by motions of this nature. Roughly 1,000 attorney hours were required to produce the government's response. The selective prosecution issue raised in Armstrong and the later case is an important and recurring one. As of May 1995, when we filed our brief in the Supreme Court, there were hundreds of selective prosecution motions at various stages of litigation in the Ninth Circuit alone. The overwhelming majority of these are either crack cases of the Armstrong type or immigration cases involving alien Latino defendants charged with re-entering the United States after having been deported in connection with felony convictions. The government's opposing submissions in these cases generally have become significantly lengthier and attempt typically to include statistical data information concerning the U.S. Attorney's Office's charging practices and affidavits from law enforcement officers involved in the particular prosecutions. These developments certainly lend credence to the Supreme Court's observation in an earlier case that criminal defendants often will transform their resentment at being prosecuted into the ascription of improper and malicious actions to the government's advocate. We feel confident that the Ninth Circuit's decision in Armstrong was wrong and that the trial court's rejection of the selective prosecution claim in the latter case reinforces that conclusion. There is no denying, however, that nationwide statistics on federal crack cocaine prosecutions by race are rather stark. Blacks comprise 90% and whites just under 4% of crack defendants in the federal courts. Moreover, there appears to be a significant disparity between the percentage of African Americans who use illicit drugs in a given year and those arrested for drug crimes who are African American. And finally, some have claimed, as did the defendants in the Armstrong case, that crack defendants who are black are more likely to be prosecuted federally and therefore subject to harsher penalties, while whites are more likely to be prosecuted by state law enforcement. Our response to these data and allegations has not been to brush them aside, but rather to explore their implications and to develop the most reliable empirical information possible to ensure that the federal government is acting fairly in this regard on a national basis. On the issue of the disparity between African American drug use and drug arrest statistics, we think that there may be several reasons to question its significance. To date, there have been no single national study conducted which compares the race of drug users and drug sellers. And it was problematic, we thought, to compare the results of studies that sample different populations, use different methodologies, and do not control for the same variables. But we think that race need not be the only explanation for any disparity, because there are empirical data to support the belief that the populations of drug users and sellers are not coextensive, and that the percentages of persons of a particular race who use a drug and who sell the drug may be very different. There's also evidence for historical and socioeconomic reasons that members of a particular race may dominate trafficking in particular drugs. For example, of those defendants sentenced federally in 1994, approximately 73% of methamphetamine defendants were white, 93% of LSD defendants were white, and only 4% of those prosecuted for marijuana offenses were black. There seems to be a segmentation in the drug market that is of interest in and of itself. In order to determine whether race plays a part in arrest decisions, it's important to control for variables other than race that may affect a person's risk of arrest. One such factor is the type of drug used. Data show that cocaine and heroin users are anywhere between 4 times, at the most conservative estimate, and 9 times more likely to be arrested in a given year than are marijuana users. This differential holds across racial groups. That is, members of all races are more likely to be arrested for cocaine or heroin use. African Americans account for a disproportionate percentage of users of those drugs that carry the highest risks of arrest. A second non-race variable that may affect the risk of arrest is the frequency of drug use. Criminologists agree that the more a person uses drugs, the greater the risk of arrest. This is not just a simple arithmetic equivalency either, because frequent drug use correlates with practices that themselves increase the risk of arrest, such as possessing larger amounts of the drug, associating with other users, and committing other crimes to support drug habits. Survey data suggests that African American drug users are more likely to use drugs more frequently than whites. Consequently, the percentage of African American users probably significantly undercounts the total drug use of that population. A third variable that may affect arrest rates is the geographic location of drug use. The data show that the risk of arrest for a drug user living in a metropolitan statistical area of over 1 million is more than twice as high as the risk for a user living in a non-MSA, in other words, a rural county. Again, this difference holds true across racial groups. The data also show that the African American population is disproportionately concentrated, I think something that we know, in large metropolitan areas. More to the point, the African American drug user population is disproportionately concentrated in the large metropolitan areas that carry the highest risks of arrest. I realize that these realities with respect to the impact of drugs on African Americans are unpleasant to confront, but ignoring them will not make them go away. The fact is that the African American community is being ravaged by trafficking in crack cocaine. A 1994 report, for example, found that 71.5% of emergency room admissions for crack involved blacks. Moreover, blacks comprise over 69% of the admissions for treatment for crack abuse, whereas whites comprise only 24%. With respect to the federal state prosecution issue, the one that was presented in the Armstrong case, the data are very incomplete. Although the U.S. Sentencing Commission, about which I'll say something later, publishes detailed information about federal defendants sentenced for crack, there is no comparable information available for defendants prosecuted or sentenced for crack at the state level. Relevant state statistics are particularly hard to come by because the majority of states do not distinguish between crack and powder cocaine for penalty or record-keeping purposes. In response to a request by the Sentencing Commission for crack data, only 3 states were able to provide even a statistic on the total number of crack cases handled in a year. In view of this dearth of pertinent information, a Justice Department agency, the National Institute of Justice, has been investigating the availability of state data and assessing what would be required to undertake a 50-state study of crack offenders. We are mindful, however, that it will not be adequate simply to compare the number and race of crack defendants at the federal and state levels. In order to permit fair comparisons, any study must control for key variables such as criminal history, possession versus distribution, whether a gun was used, and the amount of the drug involved. These variables may be relevant to any apparent disparities between state and federal prosecutions. The bottom line of all I've said thus far is that we are making serious and concerted efforts to locate explanations for nationwide federal prosecution figures that appear at a superficial level to be out of line from a racial perspective. The second area of concern arises with respect to the disparity between penalties under federal law for crack and powder cocaine offenses. The Sentencing Reform Act of 1984 was enacted by Congress to, according to its description, the rationalization and lessening of disparity among criminal sentences. Under the prior system of indeterminate sentences of federal defendants, the only restriction on judges was that they not impose sentences which exceeded the statutory maximum terms of imprisonment. The United States Sentencing Commission was created as part of that legislation to promulgate and periodically to review and revise determinative sentencing guidelines. Under the current federal sentencing guidelines, narcotics offenses involving 1 gram of crack cocaine are punished as severely as equivalent offenses involving 100 grams of powder cocaine. That disparity has been the subject of frequent criticism from various quarters on the ground that the 100-to-1 powder crack sentencing ratio has an unfair impact on racial minorities. The argument is that because as a statistical matter, minorities are more likely to use and sell crack cocaine, while non-minorities are more likely to use and sell powder cocaine, minorities are punished far more severely for equivalent offenses. Each of the 12 federal circuit courts, including the first, that has considered a constitutional challenge to the crack powder sentencing disparity, has held that the disparity does not violate the equal protection component of the Fifth Amendment to the Constitution. These courts generally have agreed that there is no evidence that Congress acted with discriminatory intent when it enacted the sentencing ratio, and that the distinction has a rational basis grounded, among other reasons, in the different addictiveness of 2 forms of the drug, cocaine, and the different levels of violence associated with their use. This is not to suggest that these courts, in finding current federal penalties for crack cocaine constitutional, have wholeheartedly endorsed them as a matter of policy. Now, that's an understatement. Indeed, in a recent First Circuit decision in which Judge Coffin joined, rejecting such a challenge, the court observed as follows: "Finally, we note that while the equal protection obligation imposed by the Due Process Clause of the Fifth Amendment is not an obligation to provide the best governance possible, the absence of a constitutional command is not an invitation to government complacency. Although the defendant has not established a constitutional violation, he has raised important questions about the efficacy and fairness of our current sentencing policies for offenses involving cocaine substances. We leave," said the court, "the resolution of these matters to the considered judgment of those with the proper authority and institutional capacity." Responding at least in part to claims of racial bias in sentencing, the United States Sentencing Commission adopted in April of this year by a 4-to-3 vote amendments to the guidelines that would treat crack and powder cocaine alike, both for trafficking and possession offenses, simple possession. Specifically, the penalties for crack offenses would be lowered to match the current levels for cocaine powder. These amendments were submitted to Congress on May 1st and will automatically become effective on November 1st unless Congress specifically disapproves them. The Commission also submitted a legislative proposal to Congress to eliminate the differential treatment of crack and powder in mandatory minimum sentences currently provided by statute. These guidelines amendments, however, are not contingent on amendment of the minimums. The Department of Justice officially opposes equalization of the penalties for crack and powder offenses for trafficking offenses. For example, under the proposed amendments, an individual convicted of distributing 50 grams of crack, that's about 500 doses of the drug, who would currently receive a mandatory minimum sentence of 10 years imprisonment, would face a guideline sentence under this proposal of only a maximum of 27 months in prison, and could receive as little as 4 to 10 months for the offense. Indeed, it's possible for the person to get out in as little as 4 months after committing what we think is a very serious offense. The Department of Justice position is that crack is a more dangerous substance than powder, and that assuming that quantity and other factors are identical, crack trafficking, therefore, is a more serious offense. The following facts support this conclusion. Crack is more psychologically addictive than powder because it can be readily smoked and results in quicker and more intense effects for the users. Those who smoke crack reach maximum physiological effects in approximately 2 minutes, and maximum psychotropic effects, that is, affecting the mind, in just 1 minute. In contrast, those who snort cocaine powder reach these effects in 40 and 20 minutes, respectively. Crack that is smoked enters the brain in just 19 seconds, compared to 5 minutes for cocaine powder that is snorted. Smoking cocaine through crack is also a more efficient absorption route than snorting powder. However, the duration of effect for crack is shorter than for cocaine powder when snorted, 30 minutes compared to 60 minutes. The duration of the effect is significant because it's related to dependency. Because of the short but intense nature of the euphoria induced by crack, the user is more likely to administer the drug frequently and in binges. In summary, we think that crack is more psychologically addictive than cocaine powder. But there are other considerations, because crack can easily be broken down and packaged into small, inexpensive quantities for distribution. Crack's low cost and high risk of addiction make it especially appealing to the poor and to the young, and street-based marketing patterns for crack generate high rates of violence and contribute heavily to the deterioration of minority communities I was mentioning earlier. Accordingly, the department has submitted a legislative proposal to Congress to disapprove the guidelines amendments that would equalize the penalties for crack and powder trafficking. That legislation was introduced in the House of Representatives in July. I want to stress that the department's proposal does not disapprove equalization of the penalties for simple possession of crack and powder. And I also want to stress that the department agrees that the current 100-to-1 penalty ratio for trafficking offenses merits reconsideration and possible change. Indeed, as one of the dissenting members of the commission on which the Attorney General sits as a non-voting ex officio member aptly remarked in his dissent, despite the commission's divided vote on Amendment 5, which is the one that proposes to reduce the quantity ratio to 1-to-1, our recent report to Congress unanimously rejected the pre-existing 100-to-1 ratio between powder and crack cocaine. We believe that that investigation and consideration is justified. Narrowing the differential would, for example, reflect the fact that crack powder can easily be transformed into crack. The department has not, however, endorsed, as I've said, the 1-to-1 ratio for trafficking, and we've not endorsed a specific ratio. We only contend that any ratio must continue to account for the systemic harms associated with crack, that individuals who deal in significant quantities of crack must receive certain incarceration regardless of downward adjustments under the guidelines that Judge Coffin knows very well, and that the ratio must provide for sufficiently harsh sentences to motivate defendants to accept responsibility for their actions and cooperate with law enforcement in the prosecution of others. But we believe that the Congress is in the best position to weigh the policy considerations related to a particular quantity ratio for the sentencing of crack and powder trafficking offenses. The last area I want to address is that of capital punishment. I should say preliminarily that the Attorney General and I found ourselves in an odd position when we came into the administration. Both of us had taken positions in our prior incarnations opposing capital punishment. We work for a president who supports capital punishment, and both the Attorney General and I recognize that the Supreme Court has on more than a few occasions upheld the constitutionality of the death penalty and shows no inclination to revisit that issue. Therefore, in our confirmation hearings, we pledge to do what federal officers are supposed to do, and that is enforce the law. But that does not mean that we do not continue to have profound concerns about capital punishment within the federal system. And I want to explain how the Attorney General has responded to those concerns. Congress in 1988 reinstituted a federal death penalty in something called the Anti-Drug Abuse Act of that year for a limited number of crimes. However, in the Omnibus Crime Bill of 1994, Congress expanded the number of federal capital crimes to more than 50. In response, the Department of Justice developed this year a detailed protocol setting forth the policies and procedures to be followed in all federal cases in which a defendant is charged with an offense subject to the death penalty. Death penalty guidelines never existed previously at the Justice Department. It should be noted, however, that prior to the promulgation of the new protocol, pursuant to motions to dismiss capital indictments based upon selected prosecutions, 3 United States District Courts conducted thorough reviews of all Department of Justice files for all pending or completed prosecutions at the time of each review. None of these courts found any evidence of racial bias or the use of impermissible factors in the decision-making process employed by the department in capital cases. For example, in a 1993 ruling by the District Court for the Northern District of Georgia, the court observed that it appears to this court that the decisions to seek a death penalty in cases presented to the Attorney General were each based on objective circumstances of each particular case which were proper and legitimate grounds for the decision. The records indicate that the decision of the prosecutor and that of the Attorney General did not in any way involve the race of the accused. And in the 1994 decision coming from the Western District of Pennsylvania, the court stated that the department's criteria, policies, and procedures, and I quote, actually demonstrate a heightened concern with ensuring that the death penalty is not unfairly imposed because of race or ethnic origin. But the history of the death penalty raises sufficiently serious concerns about the potential for racially discriminatory imposition that particularly rigorous safeguards against such practices seem warranted. Indeed, only 8 years ago, the Supreme Court, in a sharp 5-4 decision, upheld against charges of racial discrimination Georgia's system for imposing the death penalty in a case that's known to lawyers and law professors, and we hope students, called McCleskey versus Kemp. And the federal court in Pennsylvania, the court that I mentioned earlier, remarked that though the documents submitted do not suggest any intent on the federal government's part to seek, approve, or withdraw requests for the death penalty on racially impermissible grounds, it remained, it said, troubled by the skewed statistics revealing that most defendants for whom the death penalty has been sought and or approved have been black, with an additional few being Hispanics and very few being white. The new policy is an effort to provide even greater assurance that federal courts imposing capital punishment do so fairly and consistently in a manner free from ethnic, racial, or other invidious discrimination. Let me describe briefly the way the protocol works. First of all, it may not be sought without the prior written authorization of the Attorney General. In any case in which the United States Attorney has charged or intends to charge a defendant with an offense subject to the death penalty, that is, could be a possible death penalty sentence, regardless of whether the United States Attorney actually wishes to seek it, the United States Attorney must designate a person on his or her staff to complete what is called, and this is somewhat grisly, a death penalty evaluation form. That form requires the U.S. Attorney staff to set out, 1, the theory of the prosecution, 2, all statutory aggravating factors for the crimes charged, all non-statutory aggravating factors, all statutory mitigating factors, and all non-statutory mitigating factors. Because after all, under the Supreme Court's decision, there has to be a determination of a balance between aggravating and mitigating circumstances. The protocol directs the United States Attorney to enumerate only those aggravating factors that can be proved at a sentencing proceeding beyond a reasonable doubt, but to list all mitigating factors that are reasonably raised by the evidence and which the defendant is likely to be able to prove by a preponderance of the evidence. Finally, the U.S. Attorney must set out a qualitative analysis that balances the aggravating and mitigating circumstances and has to recommend whether to seek the death penalty, and explains and has to explain the reasons for that recommendation. This death penalty evaluation, along with any written material from defense counsel, is then forwarded to a review committee appointed by the Attorney General. Counsel for the defendant is offered the opportunity to present to the review committee orally or in writing the reasons why the death penalty should not be sought. According to the protocol, the committee must consider all information presented to it, including any evidence of racial bias against the defendant or evidence that the department has engaged in a pattern or practice of racial discrimination in the administration of the federal death penalty. The committee is required to submit a written recommendation to the Attorney General, who then conducts a separate review and makes the final decision in all cases whether the government will seek the death penalty. The death penalty authorization process is designed to promote consistency and fairness, a goal which is served by the fact that ultimate decision-making authority is vested in the same single individual, the Attorney General, in all cases. In conclusion, I believe that charges of selective prosecution, and I think I speak for the administration and the department, on the basis of race, or any other invidious grounds for that matter, must be taken seriously. But I also think that reason, not rhetoric, should guide our consideration of such charges. Where they prove to be true, the federal government has a constitutional duty to take corrective action. Where they are unjustified, we should be candid in saying so, even though it may involve discussing, as I have tonight, unpleasant realities about race and crime. Moreover, as the efforts of the Sentencing Commission to achieve a reduction in the current 100-to-1 ratio of crack cocaine to cocaine powder sentences, which the Justice Department has endorsed in principle, despite its disagreement with the 1-to ratio, reflect, I would like to think, that the federal government is not taking, to quote again the First Circuit opinion I mentioned earlier, the absence of a constitutional command as an invitation to government complacency. Most important, however, is that the federal government must ensure that adequate procedural mechanisms are in place, such as the department's new death penalty protocol, to guard against racially discriminatory enforcement of the laws. Our oaths of office as prosecutors and the communities we serve demand no less. Thank you very much, and good evening.
TV4, Extraordinary Television, the Community Television Network.
Join us for Eggs and Issues, the Portland Community Chamber's monthly breakfast forum with guest speakers from the community. We begin a brand new season of programs with Speaker Kevin Mahaney of PAC 95. He will discuss the making of the boat Young America that raced in America's Cup and highlight the use of boat building technology and the educational impact of this project. Starting Monday, October 2nd, watch Eggs and Issues every night at 7 here on TV4.